Mr. Chalmers entered a guilty plea. He was originally charged with murder, felony murder, aggravated assault, and possession of a firearm during commission of a felony.
Welcome to Bench Report Court Cam.
Speaking, he's here.
He's just coming right out. I didn't know he was coming out. All right.
Come on. So I'm just sharing about it. Judge, I've had the opportunity to speak with we have the state.
Yeah, we got to get someone in here. I saw Mr. Rao, and for a little while, I thought it was Mr. Abate. He had a real streamlined look.
Yeah, he was here. Mr. Rao was here. I've seen both.
You scared him off.
Big bad defense lawyer. I apologize.
It's the lion part.
There you go.
Did you manage to fetch one of the? They disappeared. Okay, well, Ms. Nix is in the room, and so it's okay. I just need to get a sense, because we're letting the jury clerk know, are we bringing in jurors for Chalmers or for Previon? And I'll be there for either one.
Yes, Your Honor. I received a counter offer from that of Mr. Chamars related to Mr. Rao. I believe he's still in the same position. I'm not sure if the court would allow it, but we'd like to potentially put it up and see what the court's thoughts are. If the court allowed Mr. Chalmers to potentially withdraw his plea if he does not agree with the court's sentence. If the court would allow that, I think we would at least be wanting to entertain a non-negotiated plea back, Judge.
Okay. Hello, Mr. Rao. What has changed from yesterday in terms of the parameters? Yesterday, it was 20 to serve from the state and time served from the defense.
Yes, Judge. And yesterday, the time served, that was more of my advantageous hopes with regard to Mr. Chalmers' case. But in speaking with Mr. Chalmers of a realistic resolution, Judge, he's at a 20 serve 5 or something around that area. If the court would accept it, we have extended that to or countered that with Mr. Rao, and he's in his position. I totally understand the case and given the reduction as well that they've offered. So that's pretty much the difference, Judge.
Got it. So state still at 20, and defense would be coming in with 20 serve 5.
Correct.
Got it. So, Mr. Chalmers, I understand what you'd like to do, which is, hey, could I have a free bite at the apple, see how it goes with the plea? And that's not how it works now. You are entitled to enter a plea at any time. You could do it today. You could do it on Monday after you look at all those jurors and say, I don't really want to go forward. You could do it halfway through the trial. Now, the state might pull back that 20 years so that once we pick a jury, they may say you can plead, but you're pleading to the indictment, which would be life. But if you want to enter a plea today, it will be what we call a blind plea. Blind meaning only you don't know what I'm going to do. I would need to hear from you and your family or anyone who's going to speak on your behalf. Obviously, your lawyer. I need to hear from Mr. Rao, and I know there are family members who want to be heard from. Would they be available today, or what we would be doing today would just be taking the plea part and confirming that Mr. Chalmers is admitting responsibility and I would find him guilty, but we would defer sentencing to a later date?
The latter.
Okay. That may be even less what you want to do, because it wouldn't be closure today. But it sounds like the state really isn't able to go forward with a plea today unless it was a negotiated plea. But if it's going to be a blind plea, a non-negotiated plea, they would want, and they have a right to have family members be heard before I figure out what I'm going to do. Because in the same way that your story would tug me in the direction of your lawyer's recommendation, I suspect the feelings of loss that that family has would tug me in that direction, which is what I hear at sentencing anyway, if there's a trial. So what you and Mr. Partridge should talk about, I'll give you some more time to talk because I can turn to this other case. Do you want to go forward today with simply locking in that you've pled guilty, and then we would do sentencing late next week or something, but you would not be able to withdraw your plea if I went with their number, or I might say, you know what, the right number is 15. That's less than what they asked for, but it's 3 times as much as what you asked for. And that may not be something you're interested in locking in, because there's not much of an appeal from a plea. You sort of, that's what you get. Whereas if you go to trial and it doesn't go well, there's an appeal. I don't mean it's going to win, but there's at least that chance. So you've got some variables in there. There's also the certainty of a plea. It's not life, and it's not life without parole. But that's a big decision to make. I know you've had a lot of time to think about it, and I'll give you a little more time to talk. But when you come back out, it's going to be up or down, yes plea, no plea, because I need to let the prosecutor know. Obviously, your lawyer needs to. Oh, what do we know from? You didn't send anything about Clayton.
I have a 3 o'clock call with the prosecutor there. I do also have a motion to continue that I filed over there as well.
Okay.
Just with how that went.
Yeah.
And then I do have a conflict letter that is drawn up, prepared, that I'll send over to Ms. Nelson as well.
All right. It's all coming down to the final hours.
Yes.
All right, we'll work through that. But why don't you guys go talk a little bit more. Before you do that, any questions for me, Mr. Chalmers? Okay. All right, you guys talk a little bit more, and let's get Ms. Bumpus back with her client if we can do that. We'll wait to see. Oh, I'll work with the 2 gentlemen. They can get out of here because I can't track their lawyers down. So, Mr. If you go on, once they're situated, can you pop the camera out on that?
Yeah.
For sure.
Good. All right, Ms. Rivers, are you able to hear us?
Yes, I am. Good morning.
Good morning. Thank you for joining us. We're going on the record in 23 SC 187611, State versus Matthew Chalmers. Mr. Chalmers is here with his lawyer, Mr. Partridge. We have Mr. Hawkins from the state. Last week, Mr. Chalmers entered a guilty plea in this case. He was originally charged with murder, felony murder, aggravated assault, and possession of a firearm during commission of a felony. The state, in exchange for the guilty plea and avoiding needing to put the Yancey family through a trial, agreed to reduce count 1, murder, to voluntary manslaughter. That took care of count 2 and 3, and then Mr. Chalmers also entered a plea to count 4. We handled last week the basics of a guilty plea. Mr. Chalmers acknowledged all the rights he has as a criminal defendant, and that he was waiving or giving up those rights by entering a guilty plea. Mr. Rao, a colleague of Mr. Hawkins, provided the factual basis for the guilty plea about the shooting at Brookwood Valley Circle that resulted in Mr. Yancey's death. I accepted the plea and found Mr. Chalmers guilty of both voluntary manslaughter and the firearms charge. I believe the state's recommendation, we'll get it on the record again, was 20 years to serve, 15 for the voluntary manslaughter count, plus the 5 consecutive for the firearms count. But we deferred sentencing. The point was to lock in the guilty plea because Mr. Chalmers was supposed to go to trial this week. And in lieu of going to trial and the risk of being found guilty and being sentenced to life, possibly life without parole, he entered the guilty plea. His lawyer, Mr. Partridge, indicated that they would be advocating for a sentence less than what the state was recommending. And we agreed to set down sentencing at a later date so that Mr. Yancey's family could be here and so that Mr. Chalmers could have people here as well. We have a number of people here in court, and what I'm going to do is turn it back over to the state, to Mr. Hawkins, to see if there is additional presentation from the state as to sentencing, not about guilt or innocence. Mr. Chalmers' plea has been accepted and he's been adjudicated guilty as to count 1, reduced to voluntary manslaughter, and count 4, the firearms count. And so we are focused this morning on what is a reasonable sentence. in light of what happened in January of last year, and then the facts and circumstances of both Mr. Yancey's life and Mr. Chalmers' life. And I'll be learning about those this morning. So Mr. Hawkins, when you're ready.
Thank you, Judge. And Your Honor, the state will be presenting the testimony of Ms. Mitchell, who is Mr. Yancey's mother. That will be the state's only witness. But I do want to get into a little bit of the facts as it relates to sentencing. I know Your Honor has heard a factual basis as it relates to the plea itself. But the state is asking this court to impose a global sentence of 20 years to serve in prison, 15 years to serve in prison on count 1, reduced to voluntary manslaughter, and a consecutive 5 years to serve in prison on possession of a firearm during the commission of a felony. And here's why that is appropriate, Judge. One, this incident occurred inside Mr. Yancey's apartment. That was an apartment that he was living at with his on-again, off-again girlfriend at the time, Miss DeVory Davis. The evidence would have shown that there was an ongoing beef or feud between Mr. Yancey and Miss Davis's brother. And so this feud did not involve Mr. Chalmers. This is not something that he was directly involved in. And it's the state's contention that Mr. Chalmers inserted himself into this feud between these other two men. Let me ask a question, because Mr. Rao shared some of this when he was providing the factual basis. Yes, Judge. The way he related, Mr. Yancey and Ms. Davis had been having an argument, and this was his characterization, but basically Ms. Davis lured, maybe that's my word, but said, hey, if you're going to talk to me like that on the phone, you need to come over. And so it wasn't made clear to me, I'm not disagreeing with you, that actually where he went was his home as well. But basically, Ms. Davis was, you need to come over and say it to my face, Ms. Davis knowing that her brother was there. Is that Mr. Compton? Or is Mr. Compton someone different? Mr. Compton is somebody different. Also, who had nothing to do with the beef, the argument. It was Mr. Yancey, his on and off again girlfriend, her brother. There was tension, friction amongst those three. And what you're sharing is that Chalmers and Compton inserted themselves into this situation. Yes, Your Honor. Okay. And what happened was Mr. Yancey did return home at the behest of DeVory, basically saying, why don't you come over here? When he arrived, his intention, according to DeVory, was to fight the brother, that they had this beef, and so they were going to settle it with a fight. They did engage in a fist fight. Mr. Yancey, I guess it depends on who you ask, got the better of the brother. The brother characterizes it differently, but there was a fist fight. The fist fight ended. It's undisputed that after the fight, Mr. Yancey was mad. He was heated. He was hot. He saw that the brother was here, and that the brother had some friends that were also there, that being Mr. Chalmers and Mr. Compton. And here being what you're characterizing as Mr. Yancey's home. Correct. Basically, these other, whether it was the brother or it was Ms. Davis, they had invited these people into his space. That's correct. Now, the brother had also been staying there on again, off again. So kind of his space too. Kind of his space too. How big is this? This is an apartment? This is a 1-bedroom apartment. Not a big space. Not a big space. Okay. So there was a couch that some folks would crash on. I'm sure air mattresses were used at the time. So the fight ends, and Yancey, all the witnesses say, go to obtain a rifle, and comes back into the common area, and while holding the rifle, so he doesn't leave the apartment. Somewhere in the apartment, he had a rifle. That's correct. And when you say rifle, there is the old school one-shot cowboy rifle. There's a AR-15 where there's a big old magazine and there are lots of rounds. What kind of rifle are we talking about? An AR-15 style rifle. Mr. Yancey, according to the witnesses, and the state didn't have any evidence to disprove this, but Mr. Yancey did grab a rifle, came back into the common area and ordered people to leave.
This is why we had an immunity hearing. I didn't hear the immunity hearing, a colleague did, but
Yes.
The guy's got a big old gun.
Yes.
And he's telling people, you got to get out of here.
That's correct, Judge. Obviously, there was some discrepancy between the witnesses as to whether Mr. Yancey leveled that rifle at anybody or pointed the rifle or just kept it in a downward position. Upon these acts, the sister, Ms. DeVore, stated that the co-defendant in this case, Mr. Compton, said something to the effect of, I'm not bothered by that, or I've got something for you. Some words that he stated before Mr. Compton opened fire on Mr. Yancey. What DeVore stated is that, in essence, the first shot dropped Mr. Yancey, that the first shot struck Mr. Yancey. He did have multiple gunshot wounds to his head, either of which would have been immediately incapacitating. Ms. DeVore stated that Mr. Yancey fell to the floor, but the gunfire continued. There were other witnesses in the apartment at the time. They would include a friend of Ms. DeVore. Her name is Letitia White. L-A-T-I-E-S-H-A. She was a friend of DeVore Davis, and let me go ahead and spell that for the record, D-E-V-O-U-R-E. The brother's name is Desuelo Davis, D-E-S-U-E-L-O. And then Mr. Desuelo Davis's girlfriend, Kelly Hernandez.
We're all present for
all present in this room at the time of the gunfire.
And it's through this group that you learned that there's a discrepancy. Some will say Mr. Yancey was pointing the assault rifle at people, and others will say he had it, he brandished it, but it was never trained on someone.
That's correct, Judge.
Okay.
Where I think this case really gives rise to the recommendation that the state is making is, again, one, this is Mr. Yancey's space. This is not Mr. Chalmers' space. This is not Mr. Compton's space, the co-defendant who's still wanted. Both Mr. Chalmers and Mr. Compton, for whatever reason, had rifles with them. They had assault-style weapons. Mr. Chalmers, when confronted by the police, although he initially denied shooting, ultimately admitted he had a Draco-style rifle, and that Mr. Compton had an AR-style rifle. So this case involves 3 firearms, all of them weapons, high-powered rifles. Additionally, as I stated before, Ms. DeVore stated, and the autopsy supports, and the crime scene supports this, that the first shot dropped Mr. Yancey. He was no longer a threat.
Wow, how can the autopsy is going to say what it can, but I'm not familiar with medical examiner testimony that is, I can tell you which shot was first, unless one was 6 days later.
Sure.
And so when they're examining the body, they can say there were 18 shots. I can tell you the direction of the shot. I can't tell you the position of the body, but the direction of the shot. But I couldn't tell you this was the first. I could tell you this one was fatal. If it had only been the 6 shots in the leg, he probably would have survived. But any one of the shots in the head would have been fatal. But I appreciate the witness testimony is the first shot dropped him. But you said something different just now, which is, oh, the autopsy shows the first shot was.
No. I apologize. I'm not trying to oversell the autopsy. What I'm saying is the autopsy supports this testimony, and I'll tell you why.
Okay.
Because it also involves the subsequent shots. The autopsy supports and shows that Mr. Yancey was in fact shot in the head. Subsequent to being shot in the head, the witnesses stated that the gunfire continued. Okay. When police arrived on scene, Mr. Yancey was deceased. He was lying on the ground. And what they discovered is that there were a number of bullet defects in the sheetrock behind Mr. Yancey's, or in front of his head, that were all low in the sheetrock, consistent with bullets traveling downward. What the autopsy revealed is that in addition to the gunshot wounds to his head, he sustained a total of 11 gunshot wounds. Many of these gunshot wounds entered Mr. Yancey's buttocks or lower thighs and traveled sharply upward with a resting point in his upper chest or maybe even exiting his chest. That would be consistent with a man lying on the ground being shot at an angle where the rifle is pointed downward at a slight downward angle. So that's what I'm saying. Those subsequent gunshot wounds support the witnesses, maybe not independently conclusively prove that, but they support the witness testimony that Mr. Yancey sustained a number of these gunshot wounds while he was lying on the ground. These gunshot wounds all entered his back. When police entered the apartment, they found Mr. Yancey lying on his stomach. The police recovered, in this case, all 3 firearms. And what is also goes towards the state's recommendation is that subsequent to the shooting, Mr. Chamars and Mr. Compton left the apartment unit and they ditched their rifles. Police were able to find the Draco-style rifle that Mr. Chamars admitted using behind a storage facility in the complex. And then a resident a day or two later found the AR-style rifle that Mr. Compton is believed to have used also on property. So these men commit this shooting. They flee out of the apartment. They ditch their rifles. And as they're leaving the apartment, a police vehicle enters the driveway. It's a long driveway to get into this complex where the gate is. And both men talk to the officer very briefly. It's on camera. Point the officer to where they need to go, but of course neglect to offer any insight as to what happened. So what this shows is the guilty conscience of Mr. Chamars. Subsequently, he is identified. Detective Sindling goes and interviews him. He initially denies committing a shooting, ultimately admits that he was one of the shooters and that he possessed the Draco rifle. Police were able to test the shell casings that were recovered from the scene. There were 25 shell casings recovered within this unit. 23 were determined to have been fired by the AR rifle that the state believes Mr. Compton wielded, and 2 were believed to have been fired by Mr. Chamars. The medical examiner was also able to recover bullet fragments and projectiles from Mr. Yancey's body. And there were bullets that were identified as coming from each rifle. In looking at the bullet that came from the Draco, that is a bullet that entered Mr. Yancey's buttocks or lower extremities and traveled sharply upward, ultimately being recovered from his upper chest, which would indicate that at least one of the 2 shots Mr. Chamars fired was while Mr. Yancey was on the ground, incapacitated, and no longer posing a threat, if at all, to the other individuals in the apartment. So, Judge, those reasons, those circumstances surrounding the shooting, of course, show the excessive nature of this shooting. This is an excessive force case. Additionally, Mr. Chamars, while awaiting resolution of his case, has been indicted for a subsequent jail event. That indictment is 24 SC 001500. It is a multi-co-defendant indictment. That indictment is before Judge Barwick. It involves, Mr. Chamars is indicted for 2 counts of violation of the Gang Act, aggravated battery, riot in a penal institution, and false imprisonment. Quite frankly, it's an attack of a fellow inmate. It's 8-on-1 or 7-on-1. The inmates made the foolish decision to video that attack and post it on social media. which gave rise to all of these men being identified and charged.
Hold on one second.
Judge, I'm gonna move to object. I believe that this is irrelevant based on my conversations with the DA's office. This case is actually being dismissed against that of Mr. Chalmers. So I'm not sure that it actually plays a role with regards to sentencing this morning if the state has already agreed to dismiss that case on Friday of last week, Judge.
Well, I'll let Mr. Hawkins respond. I think it helps paint a full picture, and they may be dismissing it in light of the plea, but you'll have a chance to share your perspective as to why whatever happened at the jail ought not to be a reason to go along with the state.
Yes, Judge, and the reason, and I can't speak to the colleague that conveyed that, but it's in lieu of, or it's in anticipation of the sentence Your Honor is about to impose, and for judicial economy reasons. There's no proof issues. It's on video, and Mr. Chalmers is easily identified in that video. So I do think it's important because I do think it goes to Mr. Chalmers' character and the appropriate sentence Your Honor should impose. I also, at this time, would like to call Ms. Yancey to the stand. She certainly knows about
Ms. Mitchell?
I'm sorry, Ms. Mitchell. Okay. Ms. Mitchell, who is Mr. Yancey's mother. She certainly knows best and can speak to Mr. Yancey and what the loss has meant to her and her family.
Before you do that, let me just hear from pretrial. I don't think we talked with pretrial when we took the plea. Just so I get Mr. Chalmers' criminal history. I don't think it could be particularly extensive because he's not charged with felon in possession.
That's correct.
But let me get that piece of information. We have Mr. York on, and then I will certainly hear from Ms. Mitchell. Okay. Good morning, Mr. York.
Morning, sir.
How are you?
Doing well. About yourself?
I am hanging in there. What can you share with me about Mr. Chalmers' criminal history?
So there is one cycle after this current arrest we're speaking of, and it was a December 20th, 2023. It's in Fulton County Sheriff's Office. It's a false imprisonment, aggravated battery, riot in penal institution, unlawful person employed by, associated with criminal street gang to participate in criminal activity through commission of offense, and nothing further, Your Honor.
So a total of 2 cycles, the one that yielded this case, and then that other arrest you're mentioning is the case that Mr. Partridge pointed out the state will dismiss should sentencing go through today. Is that fair?
That's correct. Yes, sir.
Okay. Thank you so much. Appreciate it.
Yes, sir.
All right. Ms. Mitchell, if you would come up, please. And you should sit right next to Mr. Hawkins. Good morning.
Good morning.
I appreciate you being here. I know this is not easy, and if you need someone else to read that, that's okay, but I would very much like to hear from you about the impact this has had on you and your family, and help me understand a little bit about Mr. Yancey, because of course what I hear from this incident is it's not a pretty picture for anyone. It's lots of guns and a real tragic outcome.
Okay. Your Honor, thank you for giving me the opportunity to speak. My name is Latina Mitchell. I'm here as a grieving parent of Viante Yancey Jr., who was tragically taken from us far too soon. Viante was only 21 years old when his life was stolen in a senseless act of violence. He had a dream, aspirations, and future for all promises, all for which was extinguished by the defendant's deliberate actions. I understand the state has recommended a sentence of 20 years in this case, but I must respectfully and firmly express my disagreement of this recommendation. A sentence of 20 years under the circumstances does not come close to delivering my son justice for my family, for our community that has ever been scarred by this crime. The defendant pulled the trigger that ended my son's life. There was not a momentary lapse of judgment. It was a deliberate, premeditated, and act of violence. Furthermore, the defendant has shown no genuine remorse or willingness to change. Even while incarcerated, he continued to demonstrate the allegedly lifestyle of a crime, destruction, and by engaging in gang-related activities, acquiring a cell phone to promote gang membership, committing new felonies while in jail with more pictures. These actions speak volumes about his character and his utter disregard for the law, for the courts, and for the lives that he has devastated. By granting him a reduced sentence now, the court risks being manipulated by someone who has already demonstrated he cannot be trusted. His pattern of behavior suggests he will continue to exploit the system by his own benefit while remaining in a threat to society. Your Honor, in the state of Georgia, murder triggers mandatory life sentences for a reason, because the taking of another human life is more heinous crime imaginable. The life of my son, Debilitated Yancey Jr., was priceless, and a sentence can't ever be truly compensated for which had been lost. However, a sentence of 20 years diminished the value of his life and failed to reflect the gravity of his crime. You are an experienced judge. You are wise. You have seen a lot of cases where someone get a 20-year sentence, and I trust your ability to see through the manipulation to deliver a sentence that is truly serviced by justice. I ask you to impose a much harsher penalty up to and including life in prison for the defendant. Anything less will be sending a dangerous message to the defendant, to the others like him, to the community. The courts will tolerate calculated repeat violence without imposing the full weight of the law. Your Honor, my son did not get a second chance. He did not come home to live his dreams or to grow up. I ask you, Your Honor, in his memory, by ensuring that the defendant faces the full consequences of his actions. 20 years is not enough for murder, not for my son. Thank you.
Thank you, Ms. Mitchell. Can I ask you a few questions?
Yes, sir.
I'd just like to learn a little bit more about your son. So he was 21 when this happened.
Yes, sir.
Did he go to high school?
Yeah, he graduated.
Where'd he go?
He went North Clayton High School, and then he ended up going to it was like forgot the name of it.
That's okay. He finished high school.
I'm
Did he
sorry.
have brothers or sisters?
He has a sister,
Older or younger?
younger.
How's she doing?
Not good. She don't have any other siblings.
How much younger is she?
They had to have a 11-year gap or 10,
Okay.
but their birthdays are exact week apart. They got along very well.
Definitely a big brother. For you.
Yes, very.
Okay. And what had he been doing after high school? Was he working?
Yeah, he did plenty of jobs. He worked for UPS. He worked for McDonald's, Popeyes. He always kept a job.
Yeah. Any kids?
No,
No. Okay.
he had one on the way.
With Ms.
Before,
Davis?
yes.
Okay. All right. Well, I appreciate you being here. I know this isn't easy, and it's always important to hear from family. Thank you for your time.
Thank you.
You're welcome. Mr. Hawkins, anything else?
Just a brief close, Judge. Certainly the state can't imagine what Ms. Mitchell is going through. And as I have to often tell families, there's no number that is true justice, or it's not about putting a value on your son's life or child's life. This was a shooting that had a messy set of circumstances to begin, Judge, and I think the state acknowledges that, which is why the state was willing to reduce the voluntary manslaughter, or reduce the count to voluntary manslaughter, and it's why the state is asking this court to impose the sentence that it is. The state has taken into consideration everything, including Mr. Yancey's actions prior to the shooting, but taking into account everything. And what all the evidence shows, the state believes this is an appropriate sentence and is asking the court to impose the global sentence of 20 years in prison. Thank you, Your Honor.
You're welcome. Appreciate your time. Mr. Partridge.
Thank you, Judge. Your Honor, before I go or get started, I believe a member of my client's family has a impact statement that they would like to read on behalf of the family, Mr. Chamars, if the court would allow that.
You can go in any order you want. So if there's someone here, that person cannot sit next to Mr. Chalmers, and so we'll go to the podium. So we'll have that person, if you just tell me who it is, and then he or she can introduce him or herself, and we'll hear from that person. Just follow the deputy's directions on how to get up here.
Court your name before you start.
Good morning.
Good morning. My name is Jacqueline Browning.
Good morning, Ms. Browning.
Good morning. First of all, I would like to thank you, Your Honor, for giving us this opportunity. On behalf of Matthew Chalmers' family.
Can you tell me how you're connected to Mr. Chalmers?
I'm sorry, I'm his grandmother.
His grandmother. All right.
Yes.
Now you say anything you want to say.
Okay.
Thank you.
On behalf of our family and Matthew, we would like to say that our prayers go out to Miss Mitchell and the Yancey family. Matthew is a son, a grandson, a nephew, brother, and a cousin. And he's very much loved ever since he was born. A lot of people don't know Matthew as we do. Matthew is a giving, kind, and loving and compassionate person. He's had to be because of the challenges he has faced since he has been born in his life. He's had a lot of challenges, but nothing like this. None as difficult as this is. Matthew's birth, he was diagnosed with androplasia, which is a form of dwarfism, which affects his bones, his growth, arms, legs. And due to this disorder, since Matthew has been a young child, he's had many surgeries, corrective surgeries for different parts of his body. Some had to be repeated. They were unsuccessful, and you have to continue until you try to get it straight and get it right. So Matthew has really been through some things in his life. Other people don't know Matthew like we know Matthew. Matthew stayed with me in his latter years. He finished high school, and he helped take care of me.
We can hear you. You don't need to worry about the microphone. We're hearing you just fine.
Okay.
Thank you.
He helped take care of me. He was home most of the day, and he only left out most of the time when I went to bed. Make sure I had my medication, and we lived where we have steps, and he had difficulty on those too. So me and him was talking about us trying to go and get us a place where it doesn't have any steps, because with his, and then I have severe arthritis all over my body. So anyway, he has been challenged all his life, and he's always wanted to please people because they always kind of picked on him in school, high school. And he always had to try to fight and defend himself, you know. So this is a tragedy. There is no room here, none whatsoever. This is a tragedy. And I agree. I think if I was Mrs. Mitchell and her family, I would feel this probably the same way. But my grandson, I believe, deserves another chance. He's not been a person who just went willingly trying to hurt people. He couldn't because of his size and stuff. They could always beat him. And I just want to say to the family, I'm so sorry. Everybody was in the wrong here. Everybody. Nobody was right. Nobody was right. I agree, and I know that. But I still understand how she feels, because if they had been here, they got killed. I would want her son to pay for it, just like she want my grandson to pay for it. So I just ask you. We would like to, I would like to end this by saying that we want to keep that family in prayer. I know how it is. I have lost a son, and I know, but I don't want to lose my grandson. Thank you, y'all, and the court for allowing me to talk. I'm sorry.
No apologies, Ms. Browning. Thank you.
Thank you, Your Honor. Judge, this is a very tough case. The facts and circumstances are very tough and honestly have been hard to swallow. What I see overall is a situation that was avoidable, quite frankly, from all parties. Moreover, what I see is the loss of life and life impacted of young Black men within our community as well, whereby gun violence has claimed lives or altered lives by way of going to prison and people being similarly situated to that of my client, Mr. Chamars. When I took this case, Judge, I met with my client's grandmother, Miss Browning, and his aunt, and it was just tough, and it's been tough. And in contemplating what I would say today, it's been tough as well. But I've got a firm grip on my client's perspective and just sort of what took place. So if the court would indulge me just a second, I do want to, I guess, fill some gaps maybe that the state left out with regard to what happened. First and foremost, Judge, the court can see that Matthew is a small person. He's a dwarf. Throughout his life, as his grandmother pointed out, he's had challenges and challenges that have only fueled him to try to be one of the regular kids and to keep up with them, and et cetera. And I think that this situation feeds into that. Mr. Chalmers and Mr. Compton were invited to that apartment that day by Mr. Davis, Desuelo Davis. Miss Davis, DeVore Davis, was not there, nor was Mr. Yancey. There was no mention of a beef or anything along those lines for the time that Mr. Chalmers had been there, and he'd been there some time before the shooting took place. This was the opportunity for Mr. Compton, Mr. Chalmers, Ms. Hernandez, Ms. White, and Mr. Davis to hang out, as they were. They were just hanging out. My client was in the living room just kind of hanging out and listening to music and talking when Ms. Davis arrived. Ms. Davis did not know Mr. Compton, so the first words out of her mouth was, "Who are you? Why are you here?" And they got acquainted with each other, and the kickback persisted. At some point, Ms. Davis spoke to Mr. Yancey via FaceTime. In that regard, or in that conversation, Ms. Davis and her brother, Mr. Davis, continued to talk to Mr. Yancey, and that's the first mention ever of any sort of beef. But as described by Ms. Davis when she's talking to the police, Desuelo Davis, her brother, and Mr. Yancey agreed that Mr. Yancey would come over to the house, they'd have a fight, and they'd end the beef. According to Ms. Davis, this is something that persisted since her brother got out of prison. He'd been released from prison a year before this incident took place. And Mr. Davis and Mr. Yancey would get into it often. Sometimes guns would be drawn, according to Ms. Davis. Sometimes it would just be a fight. And all the time, they would always come back to, because they were all living in this one-bedroom apartment. When Mr. Yancey got there, it's my understanding, from the state's presentation last week and today that Mr. Yancey was heated. He was upset. This fight took place. Mr. Davis and Mr. Yancey went into the bedroom. No other individuals went into the bedroom at all, just them two. They got into the fight. I believe there were some spectators that are looking into the room, Miss Davis and potentially Miss White. But outside of that, that is what happened. And that's according to all witness accounts. Witness accounts also state that Mr. Yancey won that fight. The fight was over. Mr. Desuelo Davis went to the bathroom, which is in a hallway connected to that of the bedroom. And at this time, Mr. Yancey is still fuming. Mr. Yancey goes into the bedroom. Miss Davis follows him into the bedroom, according to her. And Mr. Yancey saying that he's going to go get his gun and shoot everybody. Everybody needs to leave. This is all happening at a very rapid pace, very small window of time that this all took place right after this fight. Desuelo Davis is still in the bathroom, according to his sister. He didn't come out to talk to Mr. Compton or Mr. Chalmers to say, hey, I need y'all's help. I need y'all to do something. Do something. Mr. Chalmers testified at his immunity hearing that when Mr. Yancey went to go retrieve the firearm and came back, he was not armed at the time. He was in the living room and his gun, the Draco that he later claimed, was sitting on the couch. He didn't have a gun in his hand. All witness accounts suggest that Mr. Yancey came out with the firearm pointed and waving. In fact, in her this wasn't an interrogation, but in her interview, a follow-up interview with the police, Ms. Davis demonstrated that action, that the gun was up and that Mr. Yancey was sort of fanning it around the room, saying, everyone needs to leave, or I'm going to shoot everybody. And in the split second, all witness accounts state that Mr. Compton, also known as No Face, to everyone in the apartment, started shooting.
So No Face had his gun.
No Face, according to all witnesses, No Face had his gun ready to go. Mr. Chalmers is still in the corner. The way that this apartment is made, Your Honor, there's a couch. We'll say that this is the couch for the purposes of demonstration. This couch is a sectional that has a chase that comes off on the side. To the immediate right of this couch is a door that leads out to a balcony. To the immediate left is a doorway, an opening of a hallway. Immediately behind that hallway wall is the bedroom where the gun was retrieved and Mr. Yancey's position in this doorway area from the hallway. My client is over here. Can't really see him as far as he sees him pointing the gun, but he doesn't see anything else. Matthew has to make a decision at that point. He does not have his gun in his hand. He's standing there, he sees his gun a few feet away from him, and someone is yelling that they're going to shoot the whole house up while holding an AR-style rifle. What do you do? And then the split second gunfire starts at that point. Ms. Davis, as well as Ms. White, described the gunfire as repeated. Boom, 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 boom. That's all that they heard. Again, my client doesn't have his gun. He has two ways out. He can jump over the balcony, which with his physical limitations, his medical condition, he probably wouldn't have survived that. Or he breaks a substantial amount of bones in his body. Or he can try to make a run to this door and get out of there. He'd be in the line of fire, but he can try that. In the doorway or the hallway entry where Mr. Yancey's position is directly in front of that of the door to lead out of the apartment. Mr. Compton is in this particular area. When the gunshots erupted, Mr. Chalmers made a decision to make a run for it. made a run for it, grabs his gun, and he testified to this as well. Shot twice and ran out. The evidence supports that as well, Judge. The evidence suggests that Mr. Compton fired at least 23 rounds. That's what was recovered and related to his particular firearm, consistent with what he said, not only at the immunity hearing, but also when questioned by the detective. 2 shell casings from my client's gun were found in the apartment. He only fired twice. Left out of the apartment. What happened after that, Ms. Davis sort of gives us some information related to that. Ms. Davis says that she was out of the apartment, Matthew was out of the apartment, the other witnesses were out of the apartment. Ms. White was one of the last people to leave out, but stated that Mr. Compton was still in the apartment. So what happened in the apartment after everyone left, we don't know. But it would be my position that that would explain the bullets in the floor, or at least the one bullet that was in the floor that was found, or any additional shots with regard to Mr. Yancey being down and being shot more. The notion that Mr. Chalmers inserted himself into some sort of beef is just not how this happened. This is a very unfortunate situation all the way around. This is something that was avoidable. And quite honestly, Judge, this is very tough. Multiple lives have been affected as it relates to this. In the investigation of this case following, the witness statements were consistent. Detectives tried to explore more about this notion that there was this beef and that Mr. Yancey was lured to the apartment to be killed or to be set up. And none of the witnesses gave any information to support that whatsoever. When the police were able to identify my client, they were able to identify him and were led to that of his aunt's house. His aunt was cooperative with police and told them exactly where Matt was. They went to Matt to speak to him. There were some hiccups as it relates to that, couldn't speak to him right away. But eventually when they did, there was some apprehension, admittedly, by Mr. Chalmers. He was interviewed with his grandmother at their home. His grandmother is heard on audio recording saying, hey, tell the truth. Tell exactly what happened. If you had to do something to save yourself, let them know that. If you shot a gun, let them know that. And Mr. Chalmers told the story. He told exactly what happened. He was at a kickback. Someone came home, got into a fight, and these are people that he's been around before. So he doesn't have any beef with them or anything whatsoever. But he's been around them, Mr. Compton has not. But he tells the story about Mr. Yancey retrieving his firearm and hearing gunshots. Did not know where those gunshots came from. Did not know if it was Mr. Compton shooting or if it was that of Mr. Yancey shooting. But he knew that he needed to get himself to safety because he was at risk, which is why we filed the immunity motion. We filed the immunity motion, Judge, and it did not go our way, obviously, because of the evidence and the way that the evidence was laid out. And I understand, and we filed or at least considered an appeal as it relates to that ruling, but nonetheless, we felt strongly about it being a self-defense. We felt strongly about Mr. Chalmers being apprehensive with hearing gunshots, multiple gunshots, not knowing where those gunshots were coming from, immediately following someone waving an AR-style rifle saying that he's going to shoot everybody. Judge, as the court has heard, Mr. Chalmers is not a convicted felon. He did have the right to carry per the Second Amendment, per state law. Moreover, the case that the state has indicted against Mr. Chalmers while in the Fulton County Jail, I want to talk about that a little bit. Judge, when Mr. Chalmers was originally arrested, the advice that I gave was to stay out of trouble. Don't mix up with people. Rice Street is a very interesting place. To the tune of thousands of dollars over multiple months in his initial stay there, he's being extorted. He's calling his family almost daily, multiple times a day. Hey, I need you to send money to this particular Cash App, this Cash App. Who's doing this? I can't tell y'all because I might not be here. I'm at risk. I just need y'all to do that for me. And that's what it was. That was life on Rice Street for the first 2-3 months for Matthew. I'm getting repeated calls from his family saying, hey, you got to do something about this. You need to get him moved. You got to do this. You got to do that. I can't. My hands are tied. The sheriff has all of that. Matthew is put in a compromised position because he needs to tell someone. But if he tells someone, then does that benefit him? We don't know. So he did what he needed to do to try to survive. He's been in altercations himself where he's been attacked as well. So he adapted to that. And again, not giving any excuses or anything like along those lines as it relates to his behavior. He has this case. We understand that, Judge, but we'd like the court to understand that there's reason behind that, given his stature, given his limitations physically.
Well, I'm familiar with the dynamic at the county jail, and you need to find a group that protects you, and you protect that group.
Yes, Judge. And unfortunately, that's where he was. When he moved, he actually moved to the Union City, a different jail, the South Annex for Fulton County, Judge, and had no issues there. We wanted him to stay there. However, he was brought back to Rice Street. He was placed in an alternative pod with older prison or jailers there, and there were no issues there as well. So when placed in the proper environment, there's no issues. But when he's placed in an environment where there's gang violence, there's a lot of stuff happening every day, he made a decision. Judge, all of that said, we are not looking to make any excuses as to what happened. In speaking to Mr. Chalmers, he's been very clear. I want to take responsibility for my role, for being there, for firing my 2 shots. We didn't know for some time, because it took a while for ballistics to come back, that he had hit anything. And at least one of his 2 shots did hit Mr. Yancey. He's remorseful as it relates to that, Judge, because these are people that he considered friends. He'd known Miss Davis, he'd known her brother, he'd interacted with Mr. Yancey on a few occasions prior to this. He'd known the other people that were there as well. These are people that he hung out with from time to time. So this is not, anything that he had planned to go and, for them to shoot up anything. He's an 18-year-old man at the time going to hang out and wanting to be around young women. That was his only goal there that day, was to be around Miss White and, as he put it, kick it with her. That was it. And unfortunately, that kickback took a very sharp left turn, and we are here today. Judge, in consideration of the totality of everything that took place, I've had the very tough task of figuring out what would be the appropriate recommendation that we would set forth before the court. Initially, Jan, I will be honest with you, I felt very strongly about this case. I felt very strongly that this was a self-defense. The reason why we filed the motion was that, and I plan to argue it should this case have gone to trial. I still feel that way, Judge, and I understand that it is an imperfect self-defense, but nonetheless, self-defense as it relates to Mr. Chalmers being in that particular position, someone waving a gun and bullets erupting. Not from him, he wasn't the aggressor at all, but not knowing where it came from, so he had a very tough decision to make. And honestly, I would never want to be in that position at all, and I'm sure that no one here would. Judge, we're asking the court to consider a sentence of a total sentence of 20 years to serve 4 in prison. The voluntary manslaughter, we're asking for 15 to serve 4. followed by that of the possession of a firearm during the commission of a felony to be 5 years suspended after that 15-year period with the voluntary manslaughter is wrapped up. Mr. Chamars has been in the Fulton County Jail for the better part of almost 2 years. He would have the opportunity to go into prison and continue to serve additional time. I believe that with the facts and just how everything transpired, Judge, again, an imperfect self-defense, I believe a 20 serve 4 would be a proper recommendation for that of Mr. Chalmers. Gives him the opportunity to go in and continue to reflect on his actions and also to continue to plan and plot how he's going to move forward in the future. Judge, we have been concerned about Mr. Chalmers for this entire 2-year period as it relates to his health. You see Mr. Chalmers now, Judge, he's actually a shell of what he used to look like. He was actually a little bit more heavier when this all transpired. A little bit more heavier, a little bit tougher also for him to get around. As his grandmother pointed out, he has the issues with his bones and has had many operations and surgery as it relates to that. His legs are bowed. So he has rods that are supposed to support those, the bowing of his legs to try to straighten them up. However, Judge, those rods have now started to protrude. And so he wakes up in pain often. Some days he can't even get up and walk over at the jail. So again, just feeds into the reason why he's had to make a tough decision while being over on Rice Street, Sean. In addition to that, Judge, I alluded to him potentially jumping over a balcony and losing life, but he also has issues in the neck area as well. So if he gets into any type of fight with anyone, someone that is substantially bigger than him, or which a lot of people over at the jail would be, he runs a tight risk of being killed. Not necessarily by anything, any weapons or anything, but just being hit the wrong way or falling the wrong way. So he's a very at-risk person with regard to that, Judge, but nonetheless, he has endured and has sat over at the jail and has been waiting for the opportunity to resolve this case. Last Friday, when we talked about this, again, he stated that he wanted to take accountability for what he did, and he's doing that. Today, he stated the same thing. He's been very consistent as it relates to that, Judge. We're asking you, Judge, to sentence him accordingly. Mr. Chalmers, do you still want to make a statement at all? Okay. Would the court prefer him at the podium or?
Mr. Chalmers, you're welcome to stay right there. If that works for you, we can just move the microphone towards you. But you've got a right to be heard. If there is anything you want to share with me, haven't heard what everyone else had to say.
Good morning.
Good morning.
I just want to say I apologize to the victim family. I apologize to my family. And I just want to, I'm ready to pay my debt to society and take full accountability of my poor decisions. And that's all I got to say.
Thank you, Mr. Chalmers. Mr. Partridge, anything else?
Just the last thing, Your Honor. If the court does sentence Mr. Chalmers either way, we would ask that the court consider accepting this under the first offender and giving Mr. Chalmers first offender treatment. At any rate, this would be a sentence that Mr. Chalmers would have the opportunity to be introduced back into society, Judge. And we feel that Mr. Chalmers has understood that being around the wrong people, and even although legal, carrying firearms can be something that can be detrimental. So with that, Judge, I believe that he's taken a turn in life and will continue to take that turn if and when released from prison. So we would ask that he has the opportunity that when it gets to that point, Judge, that he has the opportunity to have a life thereafter and be able to be a productive member of society. Ms. Browning told the court that she lost a son that was actually Mr. Chalmers' father, who was also a dwarf as well. So this has been sort of a deja vu situation for this family, Judge. So we're asking for the opportunity to have Mr. Chalmers serve his time, do some probation, and come back to his family at some point, Your Honor. Thank you.
Thank you. So sentencings are often the hardest part of the work for a judge. There's some cases where it's simple because there's a mandatory sentence, it's X. And I always want to hear from both sides, but in the end, it doesn't matter how people feel about it. The law is that the sentence has to be X. That's not one of these cases. And I want to clear up a few things just so that no one leaves here confused. First, I heard very passionately from Ms. Mitchell, her frustration that she felt somehow, I don't know if that I was being manipulated, but the process was being manipulated. And I don't want her to have that fear. The state has the ability to reduce charges. And for reasons that we've heard Mr. Hawkins articulate today and Mr. Rao last week, the state has decided to reduce murder to voluntary manslaughter. That's not a decision I can make. It's also not a decision I can reverse. I'm not criticizing the decision. It's not my space in which to operate. By making that decision, the state has taken off the table a sentence of life or life without parole. That's not a legal sentence that I could impose. If I felt that the right sentence for Mr. Chalmers was life, I could not impose it here. Voluntary manslaughter, which is what the state reduced this to, I think partly fits the facts as I've heard them, but it also changes the framework where a sentence of 20 years to serve is legal, but not of life. But I understand, having heard really from both sides, why we are at that juncture now. Also, a sentence is never about the value of a life, because then the sentence should be infinite. There is an absolute value to Mr. Yancey's life. He was a living, breathing human being who deserves to be here today. And no one has the right to take that life. And so there isn't a sentence, number one, that brings him back. Number two, that fills that hole in Ms. Mitchell's heart. Number three, that brings back the big brother for Mr. Yancey's little sister. We can't do that. If I had that power, I'd be more than judge. But that loss is forever. The question is, how do we bring some closure? No one should forget, no one will forget who Mr. Yancey was and what he meant to so many people. And so nothing I'm going to say in the end about here's the sentence is in any way a reflection that Mr. Yancey's life was more or less important. It was a human life, and that is absolutely important, and it deserves to be respected and cherished. And I don't believe for a moment that the state didn't take this case seriously or is handling it one way or another because of who Mr. Yancey was. That doesn't factor into things. What factors in are the facts of the case. And it's, as Mr. Partridge said, it's a messy case. I don't know why there was a fist fight. I don't know why people think that's the way you solve something, but I do know that it sounds like what a jury would hear, members of the community from all walks of life, some of whom might relate real clearly to Mr. Yancey's situation and Mr. Chalmers' situation, Mr. Compton's situation, is that a hot room with people who were upset escalated to someone suddenly having a gun and moving that gun around. And that moves things to the most dangerous and most consequential space we can be in. Doesn't justify what happened. I want to be clear. This is, I understand that defense would be self-defense. I also understand why my colleague, Judge Dempsey, denied the immunity motion. I suspect Mr. Yancey was dead before Mr. Chalmers filed a shot. That doesn't excuse what Mr. Chalmers did. It makes me want to have Mr. Compton in this room. And I think a project for everyone when they leave this courtroom is to help find Mr. Compton. He's been indicted for the murder of Mr. Yancey. And I am confident that the state would not reduce the murder charge against Mr. Compton. You don't shoot 23 times and get voluntary manslaughter. You don't shoot 23 times where the bullets enter the behind and the head and get voluntary manslaughter. Firing your gun twice, only one of which you can show, hit someone who was probably dead when they got shot. I understand why the state moves that into the space of voluntary manslaughter. I'd also understand if they went to trial to see what a jury would do. I would not fault that jury if they found Mr. Chalmers guilty of voluntary manslaughter. They have that authority. A jury can also reduce charges. The state can, and a jury can. I cannot. One thing we get out of today, and I say we because I'm a part of this, is certainty. Mr. Chalmers has admitted responsibility. He will be punished. That's part of the sentencing. The sentence is hopefully rehabilitation, unlike Mr. Yancey, who won't ever get to hold his sister or be with his mother. Mr. Chalmers is going to get out of jail. He'll be with his grandmother and these other folks who are here for him. He has a tomorrow and the next day. Mr. Yancey doesn't. But we do need to think about where that balance falls. And he will get that additional chance that Mr. Yancey didn't. And there's clearly plenty of grief to go around. I hope, Ms. Mitchell, it touched you some, Ms. Browning's reaction. It's not appropriate for Mr. Chalmers or really his family to be reaching out to the family of the deceased while these charges are pending, because things can be taken the wrong way. And all of a sudden someone's going to the prosecutor saying, hey, Ms. Browning's calling me, wanting to talk to me. And then I'd be fussing at Ms. Browning saying, how dare you reach out to Ms. Mitchell while these charges are pending? And most of all, Mr. Chalmers is not supposed to do any outreach, because that could be taken as a threat or, hey, you need to not go forward with this. And then Mr. Partridge is dealing with new charges, that is tampering with witnesses. And that may seem that it's manufactured, that only today Ms. Browning is opening her heart, but I saw her and heard her and felt her pain for your loss, Ms. Mitchell. Again, it doesn't bring Mr. Yancey back, but I believe that she was sincere, that she doesn't want to lose another, but she knows that you have lost someone. And again, Ms. Browning's grief doesn't bring Mr. Yancey back, but I do know that there are people outside Mr. Yancey's immediate family who are grieving for your loss as well. Mr. Chalmers, you have a complicated bunch of years ahead of you. You are going to be in prison for a while, and you're going to face some of the same challenges you've been facing over the last 2 years, and some of the challenges you faced as you were growing into the 18-year-old you were when you brought a Draco with you to someone's house to kick back. Those are decisions you're going to need to make differently in the future. It was a tragic outcome. You didn't need to fire your gun in the hand. Those two shots seemed like they were at best.
Hello, is someone touching a microphone? There's a lot of
static. Let me see if there's anyone else who's on. You did everything but the podium. You had one more. Let me try this. So this is what happened yesterday, Ms. Rivers. You need to call IT. Are you able to hear enough right now?
Okay, yes. Can you hear me?
Waggle the podium microphone a little bit. Okay.
Okay.
It stopped being staticky, but it was microphone was just sitting still.
Okay, I'm ready.
All right, thank you. What I was saying, Mr. Chalmers, is that I can't shake the feeling that your shots at Mr. Yancey were at best gratuitous. It sounds like he was lying, defenseless, as I said, probably dead at the time you shot. But I also appreciate Mr. Partridge's observation that this all happened in a split second. Everyone's panicking. I'm not suggesting I would know what to do in that situation either than duck and cover and pray. But you picked up your gun and unloaded a couple rounds into, at least one, into Mr. Yancey. And that has some pretty significant consequences. Mr. Chalmers, I have found you guilty of voluntary manslaughter as well as possession of a firearm in connection with a felony. I am sentencing you as to count 1, to 10 years to serve, and count 4, 5 years to serve to run consecutive. to count one. It's a total of 15 years that you will be serving. You will get credit for the time you did serve. I will recommend that the Department of Corrections consider your medical situation in determining where you should be housed. You have very limited appellate rights because you entered a guilty plea. That is additional piece of closure that I hope Ms. Mitchell and her family will appreciate. If this had been a trial, if a jury found Mr. Chalmers guilty, what would flow from that would be years of appeals, the possibility that there would be a retrial. Years after you felt this matter had been closed, we'd be back in court. If I had made a mistake during the trial, or there had been deficient performance by Mr. Partridge, and then we're having to get at this all over again. A plea is a relatively final event. That means the only reason why anyone connected to Mr. Yancey's murder would be back here in court is because we found Mr. Compton. I will add this, insofar as Mr. Chalmers is helpful in finding Mr. Compton, that's something we could talk about in the future about making his situation different than it is today. But I think that the sentence I'm imposing, it doesn't bring Mr. Yancey back. It's not meant to place a value on his life. That can't happen. But I think it reflects the seriousness of what happened, as well as the relative difference in Mr. Chalmers' connection to Mr. Yancey's death with Mr. Compton's. I don't think it's appropriate to impose on Mr. Chalmers a sentence if the evidence showed what the state suggested would show that would be appropriate for Mr. Compton on Mr. Chalmers. They didn't do the same thing in this case. And Mr. Chalmers ought not bear the burden of Mr. Compton's crimes, in the same way that Mr. Chalmers ought not to be punished less seriously because life has been challenging for him. I have no doubt life has been difficult for you, but that doesn't get you a discount that, hey, 0 through 18 were really hard for me. So give me some credit, even though I shot this guy who was lying, if not already dead, bleeding out. That calculus is never going to work in your favor. You need to make different decisions and surround yourself with different people. Easy for me to say, hard for you to do. I get that. But unlike Deontay Yancey, you will go home someday if you make good decisions while you're in custody. For your grandma's sake and all these other people who weren't introduced to me sake, try to make those good decisions. Because that chair at the dinner table, you can be back at it in a way that Ms. Mitchell will always be looking at an empty chair. And that's the tragedy here. And I wish I could do more to make that family whole. But I think this is the way I'm bringing to close this chapter of the tragedy. And if and when Mr. Compton is taken into custody, we will move promptly to get that case to trial. I know the state will be ready. We'll simply need to get a defense attorney in place who can get up to speed, and then we'll do what the justice system needs to do in connection with that. Mr. Partridge, anything else on behalf of Mr. Chalmers?
Judge, no, nothing else on behalf of Mr. Chalmers or defense at this time.
All right, Mr. Hawkins, anything else on behalf of the state?
Can we also include a no contact provision with Mr. Compton?
So I can't really impose conditions. I set a fully custodial sentence.
Okay.
I guess I can say if you're paroled, I don't control parole. If you're paroled, a condition of your parole would be 1, no contact with Mr. Yancey's family. To me, that's more important. But also no contact with Mr. Compton.
I didn't know if that would impact, if and when Mr. Compton is arrested, if that would give guidance to the Department of Corrections of how to house these two men in the years ahead.
Well, they'll be aware they're co-defendants. First things first, let's find Mr. Compton.
Right.
I don't know that they necessarily be housed in the same place, but at the appropriate time, should fugitive find Mr. Compton, and they do good work. So I hope this is high on their list of priorities. We can worry about keeping them separate, but Mr. Chalmers, in a very short period, will not be at Rice Street, but that's where Mr. Compton would be until his case is resolved. So they would be geographically very, very separate.
Yes, Judge.
All right?
Nothing else.
All right. Thank you, everyone.
Judge, I just have one thing. I apologize. We asked the court for first offender treatment. I don't know if the court has a position either way.
I do. There are two things I still need to cover. One, I need you, Mr. Hawkins, if this is truly the state's perspective, to say on the record that you are null processing 24 SC 001500 as to Mr. Chalmers only. That's the case with Judge Barwick. And you may need to text Mr. Rao to see if that's something he had said. I recall that we weren't gonna have to then get Mr. Chalmers in front of Judge Barwick in light of the gravity of this sentence, because that's not a case that likely would result in a 15-year sentence for Mr. Chalmers. Number two, I'll let you answer that in a minute. Thank you for bringing up first offender. Mr. Chalmers, you qualify for first offender treatment. That is something for someone who's not been found guilty of a felony, that they can pursue. This case is serious enough that I'm electing not to treat you as a first offender. You will always carry the burden with you of what happened on January 14th, 2023. I think it's important that you carry that in your criminal history as well. That will make life more complicated for you when you get out, when it comes to going to school or getting a job. I think that consequence is appropriate given the significance of what happened in this case. So it was fully appropriate for Mr. Partridge to ask for it. This isn't a case where I'm comfortable given first offender status. So thank you. I needed to get that on the record. I wasn't ignoring or wanting to dodge it. I forgot to talk about it because I got wrapped up in my feelings about what Ms. Mitchell and her family are going through. That other case.
Yes, Judge. In light of the sentence imposed and my colleague, ADA Rao's previous announcement, the state will be null processing Mr. Chalmers' counts in that indictment.
Okay. We'll let Judge Barwick know that. Mr. Chalmers, that has the added effect of, I don't know that you've got bond in that case. That won't matter now. Those charges will be set aside so that you can more quickly get to the Department of Corrections, which is where I need you to get so that you don't get wrapped up in another situation like that over at Rice Street. Thank you. All right, that's it. I would ask Deputy Gordon that if Ms. Mitchell and her family want to leave first, or if they want to stay, but we have the two families leave at different times. And so if you just check with Ms. Mitchell and folks, they would like to leave first. All right, so if you're here on behalf of Mr. Chalmers, stay here, please, until Deputy Gordon says you can go. Thank you.
Talk to you back. Okay. Talk to you.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.